In this session, we're going to talk about the second half of Chapter 44 of Shareholders' Rights and Liabilities. Today, we're going to talk about the right to receive dividends, derivative actions, and distribution of assets upon the dissolution of the corporation. The 3 Ds: dividends, derivative actions, and distribution of assets. When someone becomes a stockholder and owns a part of a corporation, there are 2 general ways that that person makes money off of their investment in the corporation. First of all, the shareholder can hold on to the stock, hope that the value of the corporation continues to grow, and when it reaches a certain point, to sell the shares of stock and make a profit, hopefully bringing in more money from the sale of the stock than they paid to receive the stock in the first place. The second way a shareholder makes money from the operations of the corporation is when the corporation pays out to the owners, to the shareholders, a percentage of the profits that the corporation has earned. Paying out the profits of the corporation to the shareholders is called dividends. The decision as to whether or not a corporation is going to pay a dividend to its shareholders, and if so, the amount of that dividend, is a decision that is made by the board of directors of the corporation. Once the board of directors has decided to pay a dividend, they declare it. They say that the annual dividend or the quarterly dividend is going to be a certain amount of money per share. Once that declaration has been made by the board of directors, it cannot be taken back. Even though the dividend has not yet been paid, if it's been declared, it becomes a debt of the corporation. And at that point, if the corporation does not then pay the dividend to the shareholders would have a legal action against the corporation as a creditor of the corporation to force the corporation to pay that dividend. Now, of course, shareholders want to receive as much profits as the corporation makes as possible, but the directors of the corporation may want to keep that money within the corporation to pay for growth, expansion, research, and development. So sometimes the shareholders and the directors have a disagreement about how much money the directors should be paying out as dividends. Generally speaking, the declaration of how much dividend to declare is something that the directors make, and it is protected by the business judgment rule that we've talked about before. Courts do not want to go in and second guess the board's decision as to whether to declare a dividend at all, or if it does so, how much it should declare. So generally speaking, these decisions are reviewed under the business judgment rule. There is both a problem and a case that were assigned for today to demonstrate how a court will review the director's decision to declare and pay out a dividend. First of all, I want to take a look at problem 6. Problem 6 concerns a corporation that is named Firma Nutrients. Firma Nutrients was a long-time producer of food additives. And in fact, one of its biggest additives that it developed and sold was MSG, that food additive that they used to put into Chinese food a lot that would make a lot of us sick when we ate Chinese food. It had been a very successful corporation for many, many years. And for the past 30 years, it had paid annual dividends to its shareholders between 3 to 5% of the market price of its common shares. So the shareholders got a 3 to 5% return every year on whatever the market price of the shares was. Furman had a lot of money. It had cash of $1.26 billion, cash on hand. And it made a good earnings return every year as well. It earned on average about $610 million every year. At this point, the point that led to this lawsuit, the board of directors had decided, and I think a very good decision, is that they needed to branch out into more healthful food additives. This was a time where people were becoming much more conscious about things that were added to their foods. They didn't want the things that weren't healthy, like MSG, being added. They wanted things that improved flavor, but they wanted to make sure that the additives were more healthful. So the board of directors, taking their company in the right direction, decided that they needed to contribute a certain significant amount of time to research and development to develop these more healthful food additives. In order to pay for that research and development, the board decided that it would reduce its dividends by 50% over a period of 3 years to help fund the new direction that the company wanted to go and to pay for the research and development that would be necessary to be undertaken. The board's decision to reduce its dividends by 50% to pay for this research and development was backed by a report that had been prepared by Furman's outside financial consultants. So they had looked at the situation, they had looked at how much the research and development was going to cost, and they looked at ways to fund it, and they agreed that a good way to fund the research and development would be by a reduction in payout of the dividends. Needless to say, these shareholders who had for 30 years received annual dividend between 3 to 5% of the market price of the shares was not happy to learn now for the next 3 years their dividend was going to be reduced to somewhere about 1.5 to 2.5% of the market price. So the minority shareholders brought a lawsuit asking the court to force the directors to go back to declaring a larger dividend. In reviewing the action of Furman's board of directors, the court applied the business judgment rule. The court didn't want to get into the nitty-gritty of how much earnings or how much dividends should be declared, how much was really necessary to pay for the research and development, and second-guess the board of directors. So in this case, the court said it appeared to them that the board of directors didn't have a conflict of interest and had a rational reason to support its decision to decrease the dividends to the shareholders for this limited period of time, 3 years, in order to pay for research and development that the court agreed was taking the corporation in the right direction. So in this case, the court denied the lawsuit of the minority shareholders and said that the board's decision to reduce the dividend in the way that it had reduced the dividend was something that was protected by the business judgment rule. The next case that addresses the issue of the board of directors' right to decide whether to declare a dividend, and if so, how much, is the very interesting case of Dodge versus Ford Motor Company. In Dodge versus Ford Motor Company, the two plaintiffs were the Dodge brothers. And these were, in fact, the Dodge brothers who later went out and formed the Dodge Motor Company. But at this time, in the early 1900s, the Dodge brothers owned 10% of the common shares of Ford Motor Company. Henry Ford, who we all know as the founder of the Ford Motor Company, owned 58% of the common shares, and therefore Henry Ford controlled the corporation and its board of directors. The Ford Motor Company during this time period was an incredibly successful corporation. And from 1911 to 1915, and you really have to think about this period of time, the early 1900s, the corporation paid out a regular annual dividend of $1.2 million. And during this 4-year period of time, had paid out special dividends that totaled $41 million. So the Dodge brothers' share of that on an annual basis was $120,000 of the regular dividend and $4.1 million of the special dividends. Around this time, Henry Ford decided that the investors in the company, particularly his minority shareholders, had made enough money. They had more than been paid back their investment in the company. And Henry Ford, for reasons I'll tell you a little bit more about later, decided he really didn't want to let the Dodge brothers continue to share in this great prosperity of his company. Henry Ford, in addition to having issues with the Dodge brothers as his minority shareholders, also was a very socially conscious man. He very much took care of his employees in this early period of time when corporations did not really do that. And Henry Ford also decided that he wanted to embark upon a course of action that would get his cars into the hands of as many people as possible. And it wasn't all profit motivated. Henry Ford truly believed that the more people that had access to a car, the better their lives would be. It would free them up. It would help them be mobile. It would help them get better jobs that they could drive back and forth to. So around this time, 1915, 1916, Henry Ford decided that the company was going to reduce the cost of its cars every year by a significant amount in order to try to make the cars more affordable to more people. So in 1916, the board of directors, and remember, the board was controlled by Henry Ford, they reduced the selling price of their cars by $80 a car. And I think at this time, the cars sold for around $400, a little bit more than $400. So there's a very significant reduction in the price of the car. And the decision to do so resulted in a loss of revenue for the Ford Motor Company of $48 million. Now, look at comparison. Over the last 4 years, the Ford Motor Company had paid out special dividends totaling $41 million. And in 1916, the board makes a decision to reduce the revenue of the company by $48 million. So pretty much taking away the money that was available to pay out these special dividends. At the same time the board reduced the selling price of the cars, it announced that it would no longer pay a special dividend. That on a going forward basis, the only dividend that would be paid by the company was the regular annual dividend of $1.2 million. At the time Ford made this declaration, no more special dividends, Ford had $52.5 million in cash on hand, and they expected annual profits of $60 million. If you were the Dodge brothers, you would probably be troubled by this sudden reversal by the Ford Motor Company, and the Dodge brothers were. The Dodge brothers sued to force the board to declare a special dividend. Not just the annual dividend of $1.2 million, but to force the board to declare the special dividend as it had in the previous years. Now, a lot of this looks a lot like problem 6. The board of directors makes a decision to reduce payment of special dividends. The minority shareholders are upset and they file a lawsuit to force the board to reverse course. In this case, unlike the Furman case, unlike problem 6, the court reached a very dramatic, different decision. In the Dodge case, the court held that the board's refusal to declare a special dividend was a breach of the board's fiduciary duty to the minority shareholders. So not only did the court say, forget the business judgment rule, we're saying this was a breach of duty for not declaring a special dividend. The court went so far as to tell the board of directors the specific amount of the special dividend that it had to declare. And so the court ordered that Ford Motor Company had to declare a special dividend of $19.3 million, completely overriding the decision of the board of directors. Why is there such a dramatic difference in the outcome between problem case 6 and the Ford Motor Company case? Well, in the Ford Motor Company case, the court felt that Ford Motor Company's decision was so egregious that even though generally it would defer to a board of directors in this kind of decisions, that in this case, what the board had done was such an abuse of discretion that it violated the duty of good faith that it was bound to exercise in favor of its shareholders, and particularly in this case, its minority shareholders. Let's step back and take a look at the Furman case for a second, why the court may have felt more comfortable there with what the board of directors did. First of all, in the Furman case, they had a clearly defined plan to advance the profitability of the company by devoting significant money to research and development to create a more healthful product line, which was consistent with what people were looking for in additive companies at that time. The board had a specific budget and a specific period of time, 3 years, during which they were going to reduce the annual dividends, at which point they would go back to paying the dividends that they used to pay. Also in the Furman case, the board's decision was backed by a report by outside financial advisors. It wasn't something the board had just come up with on its own. They really studied it. They'd hired consultants to help them figure out the best way to finance the research and development that they wanted to do. In the Ford Motor Company case, on the other hand, there was a unilateral decision made by the board to just stop paying a special dividend on a forever basis. They said, we're done, our investors have made enough money, and now we want to embark upon this new course, which is to try to be charitable and help people be able to afford more cars. And back in these days, early 1900s, remember, the courts felt that the board of directors' obligation was not to be charitable. The board of directors' obligation was to be profitable for its shareholders, for its owners. So the court was offended by the fact that the board of directors of Ford Motor Company decided to force the minority shareholders to really fund the charitable actions of Henry Ford. If Henry Ford wanted to do it on his own, that was one thing, but to take money away from the corporation to do it, that's what really, for the court's perspective, stepped across the line. In this case, this is something that no outside consultants had been utilized for. It was just a unilateral decision made. Now, cut to corporations today who do things kind of like what Ford Motor Company did. Right? We have Tom Shoes. We have Patagonia. Right? We have companies that are more charitable minded. You buy a pair of Tom shoes, Tom donates a pair of shoes to someone in need. You buy a pair of Tom's glasses, they donate a pair of glasses to someone in need. Courts today recognize much more than they did back in the early 1900s, that sometimes when corporations are charity-minded, that actually does, in the long run, increase the profitability of the company. Right? Many of us go out and we buy Tom's shoes because we like the fact that they're going to donate a pair of shoes to someone who needs them if we buy from them. Right? We pay a little bit more. We're happy doing that because we know we're helping someone else out. If the Ford Motor Company case were heard today, and if there was a more specific business plan as to how this charitable-minded action could potentially increase the profits of the company, it's possible the court could have come out with a different result. It is possible that Ford could have come up with a business plan that said, look, the more people we can get a Ford car to right now will ultimately increase our profitability. Because neighbors who don't have cars will suddenly see how their neighbor who does have a car has a much better life. And the neighbor without a car may decide that they need to have a car to have a better life too. There are ways that Ford could have done their charitable giving that may have in fact increased the profitability of the company. But the problem in the Ford case was that was not what was declared to the court. Henry Ford didn't say it had anything at all to do with increasing the profits of the company. His attitude was, my investors have been paid enough. I am now going to be a better person and keep reducing the price of my cars at the expense of the profits of the company to get the cars into the hands of more and more people. All right. Now, the side note of what was going on here is at the time Henry Ford was declaring this, that he was becoming charity-minded, and that's why he was stopping paying out special dividends, there is some speculation that Henry Ford had gotten wind of the fact that the Dodge brothers were intending to take all of the profits they had made from the Ford Motor Company to go out and form their own competing car company, the Dodge Motor Company. And that knowing that may have in fact been what motivated Henry Ford to suddenly cut off paying all the special dividends. So we don't know for sure what motivated Henry Ford's decision, and that may have come across in court as well. So whatever the reason, in the Dodge versus Ford Motor Company case, the court said violates the fiduciary duties to the shareholders and required the board of directors to declare a special dividend, and in fact told them exactly how much they had to declare. A completely different outcome in Dodge as opposed to problem case 6. The next thing we're going to talk about is something called derivative actions. I actually take that back. I jumped ahead just one slide too soon. Before we get to derivative actions, we're going to talk about restrictions that are in place on a corporation's ability to declare dividends, to pay out its profits to its shareholders. What are the reasons to restrict a corporation's ability to pay out dividends? Right? We're looking at the opposite situation of what we just discussed. We're looking previously at a corporation's decision not to pay out dividends or to reduce the amount of dividends it's going to pay out. Now we have a situation where the corporation is being really generous and wants to pay all sorts of profits out to its shareholders. There are restrictions in place to prevent a corporation from doing that. The reason there are restrictions in place is because states want to prevent a corporation from paying out all of its money to its shareholders in order to leave creditors without any assets of the corporation that they can look to pay the obligation to the creditors. Let me give you an example of that. Let's say we have a corporation that has $1 million of assets and it's all in cash. And a creditor of the corporation has gone out and just gotten a judgment against the corporation for $750,000, almost all of the assets of the corporation. But the corporation wants to protect its owners and wants to screw the creditor. So before the creditor can collect on the judgment, the corporation declares a special dividend of $1 million, everything it has in cash, to be paid out to its shareholders, and immediately pays the dividends. Now, when the creditor goes to collect on the judgment against the corporation, there's zero assets to collect against. So, courts recognize corporations have the right to pay profits out to their shareholders, but not so much that it creates a detriment for the corporation's creditors. So each state has in place some law that restricts the amount of money that a corporation may pay out in dividends. And we're going to look at the restrictions imposed by the Model Business Corporations Act, because as we know, that's the act that's been adopted by the most states. And the MBCA imposes two limits, right? Two different tests. The first limit imposed by the MBCA is what's called the solvency test. The solvency test says that a dividend may not make a corporation insolvent. And what that means is that it is unable to pay its debts as they become due in the usual course of business. So the corporation may not pay out so much money as dividends that it can't pay its debts as they become due. It has to keep enough money in the corporation to be able to do that. So that's the solvency test. The second limit imposed by the MBCA is one that is intended both to protect the creditors of the corporation, but also the preferred shareholders. And if you recall, when we talked about preferred shareholders, one of the advantages of being a preferred shareholder is that when a corporation liquidates, your liquidation preference, whatever amount is set in your shares that you get when the corporation dissolves, is paid to you ahead of the common shareholders. So the balance sheet test protects both creditors and the preferred shareholders. The balance sheet test says that after the dividend has been paid, the corporation's assets must be sufficient to cover all of its liabilities, everything it owes, and the liquidation preference of all of the preferred shareholders. So creditors must be paid in full, preferred shareholders must be paid in full. That much money must be kept in the corporation. Anything beyond that can be paid out as a dividend, but not anything that impinges upon the protection for the creditors and the protection for the preferred shareholders. Now we are going to move on to talk about derivative actions. Now, the general rule with respect to a shareholder is that a shareholder has absolutely no right to bring a lawsuit for harm that has been done to the corporation. Shareholders have rights to bring lawsuits in their own name. For example, if the corporation declares a dividend and doesn't pay it out, that is a right of the shareholder, and the shareholder has the right to enforce that. But when the corporation has been harmed, that is not a right for the shareholder to enforce, even if the result of the harm to the corporation is that the shareholder's interest in the corporation has been damaged. Their shares aren't worth as much. There's not as much profit, whatever it may be. The only people on behalf of the corporation to enforce damage to the corporation and decide whether to pursue lawsuit or collection is the board of directors. They make those decisions. However, there is a certain exception to the rule that a shareholder cannot bring an action for harm to the corporation. And that is when the directors are conflicted about their decision to pursue a lawsuit. So, for those of you who have watched the Enron documentary already, you saw that the directors and officers of that corporation caused tremendous damage to its shareholders. Millions and millions and millions of dollars of damages. If the shareholders said to the board of directors, you must vote to sue yourself and your friends who are officers, and your officers too, for all of the damages you caused to the corporation, what do you think the vote of the board of directors is going to be? They're not going to vote to sue themselves. So in these unique situations, and it's largely when it's something that has been done by the board of directors, the courts have created something called a derivative action. And a derivative action allows the shareholder to sue, but the suit is brought for the benefit of the corporation, not the personal benefit of the shareholder. However, the courts don't want these types of suits, these derivative actions, to be abused by the shareholders and to constantly have shareholders bringing lawsuits claiming they're for the benefit of the corporation. So there's some restrictions and some requirements the courts have in place that must be satisfied before a shareholder may bring a derivative action. So first of all, the shareholder who's bringing the action must be a current shareholder. And at the time the lawsuit is filed, that person must hold shares in the corporation. Number two, the shareholder must have also owned shares at the time the alleged wrong occurred. This is to prevent someone from seeing something going wrong with the corporation and then run in and buy shares so that they can bring a derivative action. They had to be a shareholder at the time the wrong occurred and at the time the lawsuit is brought. Number three, it must be shown by the shareholder bringing the derivative action that that shareholder fairly and adequately represents the interests of the other similarly situated shareholders. That by this shareholder pursuing this lawsuit, that shareholder is representing not only his or her own interest, but the interest of the other shareholders similarly situated. So that usually means the other common shareholders or the other preferred shareholders. Fourth, generally the shareholder who wants to bring a derivative action must first demand that the board of directors bring the lawsuit themselves. We want to give the board of directors the opportunity to vote on bringing the lawsuit before the shareholder is entitled to do it. However, there's an exception to this fourth requirement, and that is if a shareholder can show that it would be useless or futile to make a demand on the board of directors, then this requirement is excused. When is making the demand useless or futile? That is when the board is unable to make a disinterested decision about whether or not to sue. What is the most common time that happens? It's when the lawsuit concerns something that the board of directors has done, some misfeasance by the board itself. In that case, like in Enron, it would be useless or futile to make a demand on the board of directors. Now, the next case that was assigned for this section is the case of Zapata Corp versus Maldonado. Zapata is a very interesting case. It concerns a situation where a shareholder properly brought a derivative action. The shareholder met all four of the requirements that we just talked about. So the action was properly brought. And then something very interesting happens about 4 or 5 years after the lawsuit had been pending. In Zapata, the board of directors had granted stock options to certain of its high-up executives. We talked some time ago about stock options being incentives for executives to have the value of the corporation and therefore the value of the shares increased so they can profit by exercising on the stock options. In this case, the way the stock options had been structured, if the executives exercised their options on the date that had been set, it would result in a tax liability to the individual executives. So the board of directors voted to advance the exercise date so that the executives wouldn't face that tax liability. But the result of the board of directors doing this resulted in the tax liability being placed on the corporation and therefore its shareholders, rather than the officers who were exercising the options. Maldonado, who was a shareholder, thought that this was an action that damaged the corporation because it imposed a liability on the corporation for the personal benefit of the executives. And he properly instituted the derivative action. And in this case, he had not made demand on the board of directors before bringing the action, but he had met the exception. He had proven to the court that it would be useless or futile for him to do so because he was suing the board of directors, and they weren't going to vote to sue themselves. After the case had been pending for several years, Zapata Court brought in 2 new outside directors who had not been involved in the decision to advance the exercise date of the stock options, so completely independent of this action. And they placed the 2 new directors on a committee that was a litigation review committee. And they told the directors that they wanted them to independently review the lawsuit brought by Maldonado and make a decision as to whether it was in the best interest of the corporation. The 2 new directors conducted a 3-month investigation of the lawsuit, and at the end of their investigation, they concluded that the derivative action was harmful to the corporation and should be dismissed. Now, stepping back, how is it that they could conclude that the lawsuit was harmful to the corporation? Most likely, I'm surmising, that the legal fees being incurred in connection with this lawsuit had become so large because the lawsuit had been pending for many years that it was time to cut the losses. Right? That the continuing corporation having to face these legal fees was taking away much more than what would ever be gained if the lawsuit was successful. So after concluding that the derivative action should be dismissed, Zapata Court brought a motion to dismiss before the court, saying this independent committee of the board had now made a decision without any conflict that the lawsuit should not continue on. And the court in this case imposed a modified business judgment rule, which we're going to call the Zapata rule. And the Zapata rule applies to this unique situation. A derivative action by a shareholder has been legitimately instituted, but during the course of the litigation, independent board members come in, review the litigation, and they make a decision that the litigation should terminate. And the court said, we're not going to defer to the new board because this is a kind of questionable situation. We're not just going to say business judgment rule, even though you come in and you make this new investigation, this decision. But the court imposes what's now called the Zapata rule. And the court says there's a 2-part analysis here. First of all, in this situation, where a derivative action has been properly brought, and halfway through, or even more than halfway through in this case, a decision is made by the board, an arguably independent board, to dismiss the lawsuit. First of all, the burden of proof is on the corporation, not on the shareholder. The burden of proof is on the corporation to prove that the directors voting to dismiss the action were, number one, independent. Right? No ties to the other directors. They truly are making an independent decision. Number 2, that the new directors were acting in good faith. And number 3, that the new directors had acted reasonably. In the Zapata case, the court found that these 3 elements had been proven by Zapata. The new directors that came in were truly independent, they were acting in good faith, and they'd acted reasonably. But the court said that's still not enough. Once the corporation proves that, the second step is that the court then should apply its own independent judgment to determine whether or not the case should be dismissed. Now, remember, This is a business judgment rule, and the courts don't like to get involved in business decisions. However, in this case, courts may not always have business acumen, but they do have a lot of experience with lawsuits and the costs of lawsuits. So in this case, the court can come in and say, you know what? I'm looking at the numbers here. I'm looking at all the attorney's fees that have incurred here. I'm looking at what if the best case scenario, if the plaintiff wins this lawsuit, what the benefit of the corporation is going to be. And I find the expenses, the ongoing legal expenses, outweigh that benefit. So I agree, right? It is in the best interest of the corporation at this point that the case should be dismissed. And that is, in fact, what the court held in the Zapata case. Both of these steps had been met. The corporation proved the new directors were independent, had acted in good faith, and acted reasonably. And then, having satisfied the first step, the court then reviewed everything on its own and imposed its own judgment about whether or not the case should be dismissed. And in this case, agreed. And even though the case had been pending for several years, at this point, ordered it dismissed. The final topic I want to talk about is a very short one. And this is when a corporation votes to dissolve, how are the assets of the corporation distributed? Very simply, as always, with respect to the dissolution of any type of business, the creditors get paid first. After that, the preferred shareholders. This is one of the advantages of being a preferred shareholder, that they get paid upon liquidation ahead of all of the common shareholders. And then last in line, the common shareholders. So just remember the order: creditors, preferred shareholders, and then the common shareholders. And that concludes your online remote learning of the second half of Business Law 308. You guys did a great job of keeping up. I'm very proud of you. I'm able to monitor how many, not specifically who, but how many people are reviewing the recorded lectures. You've all, for the most part, done a fantastic job of keeping up with the daily quizzes, and I know it hasn't been easy. So I just wanted to let you know I'm proud of you. Thank goodness we're almost at the end of the semester. Wishing you all the very best on the final. And boy, I hope I get to see you returning students in the fall. And graduating seniors, I wish you the very best of luck with everything. Go out there and do wonderful things in the world.